case briefs, and so much more. LSData's got what you're looking for.
The United States District Court for the Southern District of New York heard a 2006 case, Quinby v. Westlb AG, which centered on whether the court can limit the amount of electronic discovery in cases where the process is too expensive or burdensome. In such situations, the party requesting the documents may have to pay for some or all of the cost of production. The plaintiff, a former employee of Westlb Panmure Securities, alleged gender discrimination in violation of Title VII and retaliatory firing after complaining about the discrimination. The plaintiff requested the search of 19 employees' emails for certain terms, but the defendant objected. The court limited the search to 17 employees and specific search terms. The defendant sought to shift the cost of producing electronic documents to the plaintiff, but the court only granted 30% of the cost for restoring and searching the emails of one former employee. The court considered cost shifting for the production of relevant emails, but found the defendant's search was not narrowly tailored. Ultimately, the court held that the defendant had to provide a clear statement of restoration costs for the emails in question within 10 days, and granted 30% of the costs for restoring and searching backup tapes. The court denied cost shifting for expediting production and didn't consider reproducing emails in a different format. The court denied cost shifting for reproducing emails in a different format.
Case briefs, and so much more. LSData's got what you're looking for. Visit lsd.law, elevate your mind. Leave the stress of class.